Have you ever wondered about the ultimate limits of presidential power, especially when it comes to granting pardons that seem to bypass the judicial system entirely? It is a fascinating aspect of our government, often debated but firmly rooted in the Constitution. No, a presidential pardon is generally not subject to judicial review. The United States Supreme Court has consistently affirmed that the president's power to grant pardons and reprieves is an executive power that is almost entirely beyond the reach of the courts. This means that once a pardon is issued, a court cannot typically overturn it or question its validity. This broad power stems directly from Article 2, Section 2, Clause 1 of the United States Constitution, which states that the President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. The Supreme Court case of Ex parte Garland in 1866 firmly established the plenary nature of this power, meaning it is full, complete, and largely without limitation. The framers intended for the pardon power to serve as an act of mercy, a final check on the judicial branch, and an avenue for reconciliation, reflecting a deliberate balance within the separation of powers. While the pardon itself is not reviewable, it is important to understand its scope. A presidential pardon applies only to federal offenses, not to state crimes. Furthermore, a pardon cannot prevent an impeachment by Congress, nor can it restore property rights if those rights have already been forfeited by legal action. It primarily focuses on relieving legal penalties and restoring certain civil rights for federal convictions. An important nuance here is the concept of unreviewable discretion, which means the president has the ultimate authority to make this decision without external legal challenge. This power is so absolute that it can even be granted to individuals who have not yet been charged or convicted of a crime, though it does not imply guilt. While legally unassailable, the exercise of this power is always subject to intense public scrutiny and carries significant political implications for the president and their administration. In essence, the presidential pardon power is a unique and potent instrument, directly granted by the Constitution and designed to be an almost absolute executive prerogative. While it stands apart from judicial oversight, its use is a profound exercise of authority that remains highly visible and accountable in the court of public opinion and historical judgment, underscoring its pivotal role in the American system of justice.